Hi, my name is John Amy, and I'd like to thank you for being here today. To tell you a little bit about myself, I've been involved in graphics and animation since 1979. I went to college for advertising and design, and also attended tech school for mechanical drafting. I've developed graphics for video games and animation for commercials. I've worked with government agencies developing architectural renderings and walkthroughs. In 1996, as a graphic artist and animator, I became involved in trial presentation and accident reconstruction. In 1999, I began working full-time as a trial consultant at Indata Corporation, the makers of Trial Director, the trial presentation software. In 2002, I was hired by Zagnoli McAvoy Foley, a highly respected jury consulting firm out of Chicago, where I spent the next 10 years working on all aspects of presentation and technology support in war rooms and courtrooms all over the United States. As a trial consultant, I helped lawyers with presenting their cases visually, delivering evidence in a way that's more understandable, memorable, and ultimately more compelling, like PowerPoint on steroids. Now, I have my own consulting firm in St. Augustine, Florida, and as a way of introducing myself to the legal community here, I'm providing this seminar, 6 Essential Elements Using Presentation and Technology Effectively in Court. Since my first accident reconstruction case in 1996, I've worked on many different cases in varying practice areas with hundreds of lawyers and paralegals, cases that were successful and some not so successful. So what you're about to hear is a culmination of some of the best organizational methods and presentation techniques that I've come across in the last 17 years. Obviously, I won't be discussing everything today, but hopefully in the next few minutes you'll learn a few tips and tricks that you can use right away on your next case. There are many litigation presentation software out there: PowerPoint, Trial Director, Sanction, Visionary, Exhibit View, and TrialPad for iPad, just to name a few. You may have seen one of these used in court, or you may already use one of these software at your own law firm. Just so you know, for this seminar I'll be using PowerPoint and Trial Director. In my experience, the digital process is the same, regardless of the practice area you're dealing with. Criminal, civil, probate, it doesn't matter. You'll gather evidence during the discovery phase, such as documents, physical and photographic evidence, deposition testimony, as well as ESI or digital evidence contained on hard drives, smartphones, and the internet. During the discovery phase, using analytics and keywords, you'll organize this information into a case management and review system, such as summation, concordance, relativity, accelerate, among others, so that you can perform searches of the data to find what's most relevant to your case. As you progress to an actual trial date, you'll want to export your trial exhibits, deposition videos and transcripts, demonstratives, graphics, and so on, and begin building a presentation database and presenting that data at trial. It's this phase that we'll be focusing on today. The key to any great presentation is preparation. It's no coincidence that this element is the first I'll be discussing with you today. Digital presentations require more prep work prior to trial. The presentation method is also an important factor. Having the best software and computer hardware may not be the answer when it comes to presenting your case effectively in court. Sometimes a presentation board works better in conjunction with a big screen presentation. Knowing what technology to use and when to use it is part of the preparation process. We'll get into that a little more later on. So let's start with file formats. Whether you're scanning documents yourself or using a service bureau, it's important that you follow these guidelines to avoid future technical issues during presentation. Huge documents containing thousands of pages, or files containing large groups of high-resolution color photographs, or PDFs having a file size of more than 75 megabytes may start to cause delay in your presentation. If you've scanned a 200-page color document at 600 dpi and the file size is now 150 megabytes plus, you may be waiting 10 to 20 seconds or more for the first page to display on the screen. This will feel like hours when you're presenting in front of a judge or jury. In addition, you may not be able to zoom into large, high-resolution color images without long delays or actually crashing the presentation. So the question is, how do you make sure that the image you display on the screen is crisp and clean even when magnified without causing delay in the presentation? The answer lies in the image resolution and the file format you choose. There are many different digital file types, but the best used for presentation are PDF, single-page TIFF, and JPEG files. PDF files are the preferred file format for presentation for 98% of the digital evidence you will display on the screen. This file format is great for documents, photographs, graphics, and converting native files such as Excel spreadsheets, PowerPoint presentations, online content, CAD technical drawings, because you can scale the file to the actual native page size without losing image quality. It doesn't have to be limited to 8.5 by 11. However, avoid scanning black and white documents greater than 300 dpi and color documents greater than 200 dpi. If a document has become faded with time, receipts for example, scanning it in grayscale instead of black and white will improve its readability on screen without adding the extra file size associated with full color images. TIFF files are the next preferred file format for black and white images. You can scan very large images such as e-size technical drawings and still have files under 1 megabyte in size. Avoid using this file format when scanning color images, as the files will be uncompressed and extremely large when compared to JPEG files. JPEG files are the next preferred file format for color and grayscale images, in that the image can be compressed into a smaller file size without losing much of the image quality. Again, avoid scanning color images greater than 200 dpi unless extreme detail is a concern or the original photograph is smaller than 3.5 by 5 inches. So let's talk about exhibit naming conventions. Naming conventions tend to vary all over the country depending on the judge or attorneys and their own ideas about their use and efficiency. But how you identify exhibits you want admitted and shown to the judge or jury is a very important part to making a presentation run smoothly. I've listed some examples here. Some methods you may choose and others may be assigned to you by the court. Number ranges can be very effective, especially when multiple parties are involved. Each party can be given a range of numbers in blocks of hundreds or thousands. You just need to be sure that the block range is realistic. Upon cross-examination, exhibits will no doubt be offered for impeachment purposes throughout the trial, continually expanding the trial exhibit list for both parties. If either side runs out of their assigned allotment of numbers, the court will have to start a whole new range of numbers. If it happens again, especially in a lengthy trial, it will add confusion and database tracking problems down the line. Now the number itself is short and easy to use, easy to say, easy to reference in an outline, and technologically speaking, easy to type by the presentation tech with less chance of human error. The plaintiff and defense exhibit numbering method is a good alternative. By using the PX, DX, and JX numbering method, you can easily add to the exhibit list by simply using the next consecutive number. As trials move towards a fast-track approach by the court, joint or pre-admitted exhibits are becoming more commonplace. These are exhibits that have been ruled upon prior to the jury being seated. This saves much of the jury's and the judge's time during trial, as it avoids many sidebars and excusing the jury to argue the admittance of an exhibit. Sometimes the judge will assign exhibit letters to one side and numbers to the opposing side. Now, letters and numbers can distinguish plaintiff exhibits from defense exhibits, as long as you know what the code is. It's very important, however, that the side that is allocated letters do so using a triple letter combination to ensure that they don't run out of letters. From a database standpoint, this triple letter combination will allow up to 17,576 individual trial exhibits. The letters will be followed up by page numbers, which will allow for better exhibit sorting and page identification. The disadvantage to this alphanumeric numbering system is a higher likelihood of typing errors, mistyping in an outline, mistyping when creating a barcode, or mistyping during a presentation. Now, this can lead to disaster. Anything that reduces the likelihood of human error will increase the smoothness and effectiveness of your presentation. What about referring to exhibits by Bates number? Well, depending on how many parties are involved, you could have several sets of Bates numbers, and in my experience they can be quite long. You will no doubt want to direct the witness using the last 3 or 4 digits of the Bates number rather than reading the entire thing. Without knowing which Bates number you're referring to, it's more likely to cause confusion than clarification for your presentation. Also, Bates numbers often employ an alphanumeric numbering system. And as mentioned before, with any alphanumeric numbering system, there is a higher likelihood of typing error. Sometimes, to make an exhibit more complete, you'll want to combine multiple exhibits with varying Bates ranges into one trial exhibit. This can make the exhibit nearly impossible to navigate with a witness effectively when using Bates numbers alone. Some courts will simply take the initiative by assigning a number in consecutive order to each admitted exhibit, regardless to what you've named it on your exhibit list. This can create all kinds of tracking problems in both your case and presentation databases, not to mention additional work required to update both systems on a daily basis. It's best to avoid this scenario whenever possible, but you may not have a choice depending on the rules of the court. Whatever the naming convention might be, it's important to identify exhibits by their trial exhibit number rather than a description. The June 8th email, for example. In most cases, there are but a handful of key documents or physical evidence that will be referred to over and over again. Once admitted, you may want to identify them by their description. You can, but call out the trial exhibit number first so that the record is clear and everyone, including the judge, witness, opposing counsel, and your presentation tech, can refer to the exhibit quickly. We'll talk more about this later. It's also important, especially when combining documents and before you make multiple copies of exhibits, to blow back documents with trial exhibit and page numbers. This will help to ensure that everyone will be on the same page when it comes to presenting the exhibit. A question that always comes to light during the preparation process is, do we need anything in hard copy when most, if not all, exhibits are being presented digitally? The court may even ask for a digital copy of your exhibit list and trial exhibits so that they can reference and view them at trial or to help them rule on outstanding motions. Though it would save a great deal of time and copying costs, I have yet to attend a trial anywhere that has been totally digital, and the reason is simple. Opposing counsel will try and trip up your rhythm by objecting to the most mundane issues, and unfortunately, the display of a digital document has one disadvantage that they can and do object to. The objection goes something like this. Your Honor, can the witness be permitted to see the entire document for identification and completeness? Or, with all due fairness, can the witness be provided with the entire transcript for context? Or, we don't have this exhibit, Your Honor. Can counsel provide us with an entire copy before showing it to the witness? These interruptions or objections just add delay and confusion to your presentation that could otherwise be avoided by providing the witness, the judge, and opposing counsel a witness notebook. On direct examination, the notebook should be number tabbed to include hard copy of all exhibits to be used with a witness, including any related graphics or slides, and a copy of the witness deposition transcripts. There should be a copy for opposing counsel, witness, judge, and the presenting attorney. It's possible that some of these documents won't be used during the course of the examination, but it doesn't matter. Your presentation will appear more professional, and it will show the judge and the jury that you are prepared. The presenting attorney's binder should also include his or her witness outline and witness exhibit list. On cross-examination, it's important to include only those exhibits in the binder that have been previously admitted or discussed with other witnesses. Additional exhibits used for impeachment purposes should be put aside in a separate folder with 5 copies each. Though time-consuming, this approach leads to a more dynamic presentation and adds suspense to the cross-examination, as well as the element of surprise to opposing counsel. It's important throughout the trial that a record be kept of trial time and exhibits that are marked, admitted, or given judicial notice during the presentation of evidence. To accommodate the multitude of cases brought before courts, judges must incorporate time restrictions in both criminal and civil matters that require lawyers to work within strict time constraints, not only in filing motions, but in trying their cases as well. Judges with tight schedules and limited time can enforce these time limits with drastic consequences to the case, including the inability to cross key witnesses or present the evidence the party may need to win their case. Many civil cases are highly complex, involving multiple parties and each having their own legal team representing them. To ensure everyone gets their fair share of time, you have to track it, and until now that was a tedious process. Court Logger Pro makes it easy. Designed for court staff, trial attorneys, trial technology consultants, legal assistants, paralegals, and shadow jurors, Court Logger Pro tracks individual witness time on the stand, admitted evidence, and daily commentary notes. Track the time for opening statements and closing arguments. Quickly and easily track marked, admitted, and noticed exhibits, complete with objection references, what witness the exhibit was admitted, and date and time references, all with one simple click of the mouse. You can use the daily commentary to enter notes on how you think the trial is going, track witness or jury reactions, and note important court rulings and calendar events. Easily generate customized daily reports that include the breakdown of trial time, witness time, and a detailed listing of admitted or marked exhibits, and your daily commentary by the day or for the entire trial. You can also choose to register the product as a subscription service. This allows the vendor or law firm to bill the time used for Court Logger to their client as an expense without having to incur the purchase of the program themselves. Depending on the trial length, you can choose up to 4 weeks, 28 days, in blocks of 7 days each for only the time that you need to put on your case. We also provide an ultra-mobile PC to our clients whenever we go to trial because the paralegals love the program. It also has the ability to capture real-time feeds from the court reporter without cumbersome and costly token charges. Another important key to preparation is the presentation outline. Now, some attorneys write outlines like basic roadmaps, showing them in brief detail where they want to go. Others write outlines word for word, like a screenplay, in the hopes that they stay on track and don't miss any points. This really depends on the presentation style of the attorney. There are some that may not write outlines at all. This can be a nightmare for the attorneys, paralegals, and other support staff that need to anticipate or second guess the presenting attorney's views on the case. A hard copy or the slides or the witness notebook may be all they need to present their case dynamically and effectively. This, of course, depends entirely on how well the attorney knows the material they are presenting. When an outline is used, it is very important to include trial exhibit numbers with specific page references, graphics, and specific slide numbers, exactly where they need to go in the outline. Deposition video clips or transcript designations used for impeachment purposes should also be noted accordingly. Another way to streamline the presentation of documentary evidence is to pre-treat the presenter's hard copy exhibits. This trick can lead the presenter quickly to the right sentence or phrase, eliminating any delay from having to read through the entire document to find it. Though it can be done and is often requested, it is not recommended to pre-treat the digital presentation copy of the exhibit during direct examination, since it can initiate a leading objection. Since all of this annotation can be done live during the witness's examination, it's better to highlight the specific passages in the presenting attorney's witness notebook to be more effective. We'll talk more about this later. Next, we need to talk about the preparation of video deposition designations for use at trial. But the first thing we need to talk about is the video quality itself, because that will be a determining factor on how effective your designations will be in court. It's extremely important that you have the video digitized properly, and I always get asked, what is the best video quality for reliable playback? So here are the specs you need to provide your media vendor. Just choose one of these depending on the device you'll be using. Standard resolution will take less time to copy and will play reliably on just about any PC, but the quality is so-so. High quality will be larger in file size and give you crisper detail and is best used with a high-end gaming PC. MPEG-4 is best used when presenting video from an iPad. This is a little technical but extremely important. Not adhering to these video standards can lead to playback and transcript syncing problems and will cause delays and unwarranted frustration. Make sure when you order digital video deposition testimony, your media vendor QCs their product before sending it to you. The product must be devoid of the following issues, or what I like to call the 13 mistakes made by media vendors. A bit rate that is too low. The bit rate determines the pixel quality of the image. Bit rate is like DPI when printing. The fewer dots printed, the lower the quality of print is produced. A lower bit rate can create smaller files, which in turn allows for more video to be stored on a CD or DVD, but this also degrades the video by introducing stair-stepping or jaggies into the video, producing poor image quality. Digitizing the video with the wrong aspect ratio stretches the image and will produce video that makes the witness look too fat or too skinny. For example, if you took today's high-definition screen, which is at a 16:9 aspect ratio, and then squeezed the image to 4:3, which is what you would see in an older standard definition TV, the image would look tall and skinny. If you did the reverse, the image would look too short and fat. It's always best to record your deposition in stereo. Recording video using a single audio channel, especially no left channel, can lead to problems during playback in court. Some videographers use a left channel for the attorney asking the questions and the right channel for the witness. Others use only the left channel for both. Depending on how you have your equipment set up in court, if you only use the right channel, you could play the video and find out you have no sound because the courtroom is only wired to receive the left channel of audio. Low audio levels during recording can make it difficult to hear even when raising the volume to maximum. Clipped audio is audio distortion caused by setting the mic volume too high during recording. This causes missing audio and audio that is distorted beyond recognition. Video prepared for internet streaming rather than computer playback can cause delay in playback as the video buffers into memory from one clip segment to another. Using a variable bitrate, or VBR, can cause errors during syncing, clip creation, and playback. It's always best to use a constant bitrate, or CBR, when encoding video. Audio-video gap occurs when video is captured and the sound card capturing the audio lags behind the video by just a few milliseconds. If you've seen this before, it looks like a badly dubbed kung fu movie from the 1970s. This lag creates lip sync drift from the beginning of the video and progressively gets worse towards the end of the video. CDs or DVDs that are partially burned can create media that cannot be read or copied. You'll discover this when trying to copy the data from the CD or DVD, and you get this dreaded cyclical redundancy check, or CRC error. The only thing you can do is have the vendor send you another copy of the disc. Mislabeled media, either on the disc itself or mislabeled media files, creates confusion. This rarely occurs, but it does happen. Inverted time codes during the time coding process creates video playback that repeats itself. This cannot be fixed during the clip creation process, but must be fixed during the time coding process. Missing time codes can create clip creation problems as well. Media that is linked out of order will make the playback of synced video clips impossible. Watching a witness by video deposition can be a tedious task for your average jury, especially if the discussion isn't relevant to the case. There is nothing more irritating to a trier of fact than to feel that their time is being wasted. Here are a few things that you can do to make your designations more effective. The golden rule is this: keep it short and to the point. Remove irrelevant commentary. For example, attorneys having discussions with their witness or opposing counsel off camera, or discussions when would be the best time to take a lunch break, or interruptions by the videographer to change the videotape, or discussions with the stenographer about exhibit numbers and their sequence, or questions that ends with "strike that" or "I'll rephrase." All of this commentary should be removed from the deposition presentation. Remove objections in most cases. Objections that aren't sustained by the court take time from your presentation and may be confusing to the jury. Now, there are times during cross-examination when the attorney is asking questions that may be damaging to the witness and opposing counsel continually objects to the line of questioning. These you may want to keep just for effect. Otherwise, remove objections entirely. Cut dead air time, consisting of more than 15 seconds. Dead air time occurs when a witness is asked to read or request to read a document to themselves or identify a lengthy exhibit. It also occurs when an attorney is writing something down and then thinking about their next question. Cutting wasted time and commentary from your presentation will be appreciated, and the points that you are hoping to make with the jury won't be lost. A foreign language deposition can slow down your presentation by a factor of 2. First, you have the question in English, then the question is translated. Then there is the witness's answer, which again is translated back into English. When dealing with foreign language depositions, many judges won't have an objection to editing the video to make it more bearable to watch. An effective way of doing this is by removing the translated question and then dubbing over the witness's answer with the translator's English version. This way, you're using the same amount of time as you would with any English-speaking deposition. However, you need to prepare for this in advance, and here's what you need to consider before taking the first deposition. To avoid possible objections made by opposing counsel, make sure you use male-to-male and female-to-female translators. Hearing a woman's voice dubbed over a male deponent, and vice versa, can lead to objections. Using the translator's voice from the deposition also ensures that no additional translations are being added to the certified deposition. Above all else, make sure that you notify both the judge and opposing counsel that you are editing the video in this fashion, so that they won't be surprised on the day of the presentation. When arguing this method of presentation, have a few examples to show the court to assure the judge and opposing counsel that this is a viable method and will save the jury hours of wasted time. I was supporting a trial in California not too long ago, and we had 18 Asian video depositions that involved translations. We had spent considerable man-hours and thousands of dollars developing the video, syncing transcripts, and creating clip designations in this fashion. But in that case, the attorneys had failed to use male-to-male and female-to-female translators about 89% of the time. And even though we had suggested on numerous occasions, they also failed to notify the judge and opposing counsel of their intentions prior to the day of presentation. In the end, of the 18 deponents, only 2 depositions were allowed to be played because of these issues, and the rest were read into the record. Don't let this happen to you. Another way to save time in preparation of video designations involves the format you use to create your designations list. If done correctly, you can use this list not only to inform opposing counsel and the court which designations you intend to use, but you can also use it to create the video clips themselves. Trial Director and Sanction, for example, will allow you to create video clips using a batch create process by simply cutting and pasting the list in a notepad and making a few minor edits. To format this list properly for Trial Director, just follow the examples shown here. Start the list with the witness's last name, and then the first name, and then the date of the deposition on the same line. Hit return and begin the list of page and line designations as shown here in this example. It's also important that there are no spaces between the colons and dashes. Also ensure that the page line to page line designations reflect the removal of irrelevant commentary and objections, as mentioned before. This is a standard format that is used every day in courts and law firms all over the country, and you can make it work to your advantage by following this simple process. When compiling this list, it's very important that the list is checked over thoroughly for errors. Many times when designations are argued in court, copies of the transcripts are prepared using a color code method. For example, yellow for plaintiff, blue for defense, green for plaintiff counters, and red for defense counters, and so on. When the designation list is used during the color coding process, you will usually find mistakes in the list at that time. Check for missing questions or answers, questions that are starting mid-answer, ending in mid-question, or just don't make any sense, are usually due to the list creator using a draft of the transcript rather than the certified copy, and the correct page line reference could be on the next page or the page before. Take the time to watch the final video in its entirety. Does it play correctly? Does it make sense? Is there anything else you can cut to make it less time consuming and more to the point? Make sure the final designation list reflects all edits, additions, or deletions before you import the list for video clip creation. If done correctly, this simple list can save you hours of editing time. Confucius said, "I hear and I forget. I see and I remember. I do and I understand." This statement is as true today as it was over 2,500 years ago. Recent jury research suggests that fully 65% of verbal communication is retained longer in memory when combined with visual stimulus than just verbal communication alone. The OSHA Office of Training and Education at the U.S. Department of Labor found that as much as 83% of human learning occurs visually, and the remaining 17% through other senses, 11% through hearing and processing text, 3.5% through smell, 1.5% through touch, and 1% through taste. Now, since most jurors aren't going to be smelling, touching, and tasting the evidence during the course of a trial, we're really left with the visual and audio stimulation. Scientifically, we know that the brain processes audio and visuals separately. This especially applies to text. When reading, the brain does double duty as it first processes the information visually through the visual cortex, and then the text is converted into internal verbal dialogue by the auditory cortex. This is precisely why people can't listen and read at the same time. They have to choose one or the other. Unfortunately, if you have a lot of text on the screen, bullet points made up of full paragraphs or sentences, you are actually going to be less effective. When the screen is used primarily for graphics, very little written information, the listener will correctly process what the attorney is saying with their auditory cortex, while at the same time processing what is on the screen with their visual cortex. This format results in better learning and memory retention. This becomes difficult when presenting evidence because much of what you're displaying will be text from documents. For this reason, it's important to read what's on the screen verbatim and avoid paraphrasing if possible. If you paraphrase what's on the slide, the jury will flip back and forth from reading to listening in an effort to correlate what you are saying with what they are seeing. This results in confusion and lack of memory retention. If you must paraphrase from a slide full of text or a large paragraph pulled from a document, a better alternative would be to highlight the text you are going to paraphrase and then read that verbatim. Using a mix of presentation media can be very effective, and all of them require some form of pre-trial preparation. Since there is usually a rush when it comes to graphics for opening and closing arguments or expert witness testimony, it's very important that you start your creation process early. Keep a graphics notebook or journal, and when ideas come, write them down. Doing this throughout the case, from discovery to closing arguments, could save you hours, if not days, and many late nights at the office trying to come up with graphic ideas from scratch. Here are a few general tips on effective graphics. Use graphs instead of spreadsheets. Show percentages as pie charts. Use figures, case-related photos, and repetition to help explain complex issues. Computer software such as Trial Director and PowerPoint are a very dynamic combination of presentation software, and has been proven successful time and time again, from the smallest hearings to some of the largest, most publicized trials in recent history. If you are not an expert with the technology in the courtroom, then bring someone who is. Even if you are capable of running it, I usually say don't. That's because an attorney's attention should be focused like a laser on the witness, the jury, the judge, and the other side, not the keys or the touch screen of an electronic device. We'll talk about this more in a few minutes. When using a computer presentation system, a document camera, or ELMO, is generally used as a backup source just in case something should happen to the computer system, such as a system crash or missing exhibit. But there are times when this equipment can be used creatively. Using a document camera and a highlighter may add more drama and interest to a key document by showing the jury that the exhibit in your hand is special and must be handled differently from the others shown from the computer system. During expert testimony, for example, you can run into leading objections when trying to use a pre-designed graphic that illustrates the expert's list of opinions in front of the jury. To avoid this delay, you can ask the expert what their opinion is and use a blank sheet of paper with the document camera to show the list as it is being created in real time on the big screen. Presentation boards should be used sparingly and in conjunction with the presentation screen whenever possible. Huge timelines with massive detail are to be avoided when using the presentation system, as they are overwhelming to look at for brief periods of time and may be difficult to read. A timeline mounted on a 3x8 foot presentation board, in conjunction with the fluid images on the big screen, can help the jury reference and remember events in time more effectively. This will require pre-trial preparation time for printing and mounting, but it is well worth the effort. Just remember to make sure that it can be folded in half for easy transportation. Other media can be used for more specialized applications. Animations used for accident reconstruction or patent infringement can easily be presented on the big screen for maximum impact. Since animation must be rendered and must meet guidelines for admission, it's very important that preparation time is given to it. Flash animation can be used for interactive charts and graphs. A timeline with linked exhibits is one example. Physical models need their own preparation time as well. In a product liability case involving tires, for example, instead of trying to show the jury the inside of a tire using a flashlight, a micro camera could be attached to the presentation system, allowing an expert witness to show the jury in real time and in high resolution forensic evidence of defects or damage caused to the product prior to its failure. Training the attorney or expert on its use and testing distances and courtroom maneuverability is key to effectively utilizing this or any other mobile technology. Regardless of the media you choose, it's important to consider your audience and try to anticipate their reactions to your presentation. Will the judge or jury understand the graphic or take it out of context? For example, when defending a pharmaceutical case, if you're trying to show that very little brain damage was suffered during a hemorrhagic stroke, allegedly triggered by your client's drug, it makes no sense to blow it up on the big screen to show how small it is. I was at an arbitration of 3 judges in Denver, and the lead attorney, a well-respected partner who managed the litigation section of a very large law firm, had us edit an old Western movie to show the judges that a big bad gunslinger had moved in and was taking over the town. This was for opening statements. Against our recommendations, we spent considerable time editing the 4-minute piece, and upon presenting it to the panel, they stopped us about 30 seconds into the video asking us, "What does this have to do with the case?" There was some argument over the relevancy, and we continued playing the video. Another minute went by, and we were interrupted again by one of the judges. "Okay, we get it. Can we move on?" So we cut the video short and moved on with the rest of the opening. If you don't think of your audience, you could be wasting your time and money on ideas that simply don't work for the audience you're presenting to. The second element involves the courtroom, its layout, and figuring out what equipment will work best in the space allowed. The first thing you should do is an on-site courtroom evaluation. Look at the courtroom to get an idea of where the judge sits, the jury, the witness, counsel tables, and where the lectern is located. The rules of the court may vary on where the attorney may stand for opening and closing arguments or questioning witnesses. For example, the attorney may be allowed to stand at a lectern or required to remain seated at counsel's table. This information is good to know considering line of sight issues on where to position presentation boards, the document camera, and any easels or flip pads. Draw a quick sketch of the courtroom and try to consider the actual size of the room. You'll need to note in rough dimensions the depth and width of the room as well as ceiling height. This will determine the maximum screen size and its location. One trick you can use to estimate the size of a room is estimating the size of a ceiling tile and counting those. You can also walk off a 10-foot section of the wall and guesstimate the length and width that way. Note how many electrical outlets there are and their locations. Some older courtrooms may not have enough power to run your hardware, and you may end up blowing a breaker every time you switch on a projector. It's a good idea to contact the courthouse IT department to request an upgrade in electrical outlets, or you may have to run extension cords from outside the courtroom to make your setup work. Also, note the ambient lighting conditions. This will determine the brightness of the projector you will need. Bright lighting will wash out the projection screen, and this problem is more prevalent when playing deposition videos and animations. Documents and other graphics may be less affected, but washout can be a hindrance to giving an effective presentation. A brighter projector, at least 4500 lumens, will be needed to get a good visual image where bright lights or windows may be an issue. You may also be able to save on budgeting costs by asking the court what equipment they have on hand and if you need to reserve it. Some courthouses have spent considerable funds equipping their courtrooms with presentation technology and would prefer that you use their equipment rather than bringing in your own. Some judges may have restrictions on what you can bring into their courtroom and may even have their own preferences on where you can install the equipment. Be aware that federal courts often have more security restrictions than county or state courts. As a precaution, you may want to get a letter from the presiding judge authorizing the install of your equipment. The letter should contain a detailed listing of the pieces you will be bringing. You'll also want to include the names associated with those that will be bringing in equipment and those that will be bringing in notebook computers on a daily basis. This could save you hours of delayed setup time waiting for security to authorize your entry into the building. In the end of this exercise, you'll have an equipment list and design layout. This gives you a blueprint on what's needed and where it goes. By thoroughly thinking this through on paper, it will speed up the actual installation of the equipment considerably. You can also give a copy to opposing counsel for negotiation on splitting costs of the rental. Once you've determined the layout design of the courtroom and what equipment you will need, you should also think about long-term costs that are involved in renting equipment versus buying it. If the courtroom is pre-wired or opposing counsel is providing the equipment, then this really isn't an issue. Or if the trial is less than 6 weeks, it would probably be best to rent the equipment from a local service bureau or national rental facility. Due to the continual dropping costs of computers and presentation technology, purchasing equipment for a trial lasting 2 months or more could be a wiser choice. At this point, you could actually purchase the equipment for less than the rental costs in most cases. Owning the equipment does have certain advantages. You could charge future clients for the use of the equipment at a discounted rate, or use it as a value-added service to strengthen your client marketing. This, of course, is your decision, as there are many things to consider. For example, the annual number of cases that actually go to trial, the cost of maintaining the equipment, and additional replacement costs, as well as staff training and setting up and troubleshooting the equipment. Try and schedule your equipment installation at least 2 days prior to the actual trial date. If opening arguments start on Monday, install the equipment the Thursday or Friday before. Many things can happen that can delay the equipment from working as planned. Late delivery, missing or broken equipment, computer compatibility issues, just to name a few. It's best to have the time available whenever possible to address any issues that could delay your presentation. The court may not have more than an hour or two between jury selection and opening statements for equipment setup. If that is the case, you will need to plan for this and make sure the people who are in charge of setting up the equipment have been notified in advance to ensure that they have the staff and resources on hand for a rush setup. Once the presentation system is installed, it's very important that the system is tested with the computers that will be used to present the case evidence, and whoever is running the equipment is aware of its operation and maintenance. Also ensure that everyone can see what is being presented, either on the presentation screen or individual monitors or presentation boards from varying angles in the courtroom, including the bench, jury box, witness stand, and both counsel tables. The third essential element is the war room and what makes up a good production environment. Even the absence of some of the most basic technology comforts readily available at your office can have a huge impact on your productivity in a remote war room location, like PBX phone extensions, printing, copying, scanning, and so on. So let's go over a few considerations. First of all, where is its location? Are you working at local counsel's office, a rented office space, or from a couple of conference rooms at a nearby hotel? If an emergency arises, how quickly can you travel from the courtroom to the war room and back? And is the distance reasonable? How many staff and attorneys will be on site? And will the space accommodate the staff, production equipment, exhibit storage, and witness preparation? Many times we'll set up a war room so that the production staff and equipment is located in one room and the witness prep area is in an adjoining room. It makes it very difficult to work effectively, making copies and scurrying about when the lead attorney is trying to prep a witness or a dry run opening or closing arguments. It's really best to do this in a separate room. What production equipment will you need, and what equipment is already available to you? If you're at a law firm, then this may not be an issue. Hotels typically have a business office, but in my experience, this is used as a last resort. The client's budget, size of production, and workforce will determine the best solutions for this equipment. You want to think of reliability, security, and high speed when outfitting your war room. The nights will be long enough without having to wait around for a slow production environment and broken down equipment. You'll also need a secure high-speed internet connection to access your home office database or email. This may be more complicated when it comes to products provided by a hotel or other off-site location. It's important to acquire a dedicated hardwired connection rather than a wireless or shared network that is being utilized by all the guests in the hotel. A hardwired connection will also add to the connection speed, since you don't want a lot of downtime waiting on files back at your office. Just be aware that costs for a dedicated system running between 25 and 100 megabits per second can run between $10,000 and $15,000. There may be debate among IT professionals on using software or hardware-based VPNs. But in my experience, the hardware versions provided by Cisco, 3Com, and Linksys are better suited for war room use. Software or client-based VPNs are often less expensive, but for performance, ease of use, reliability, and flexibility, hardware is always best. You'll also need a network switch with enough ports to give your trial team access to your network. I usually bring along a 16-port gigabit switch and an ample supply of Cat5 cables, and that usually does the job for most cases. Since you would be connected to your network WAN, something else you might want to consider is using a voice over IP phone in the war room. Using this technology, you can make calls from the war room using your internal 4-digit extensions without needing to punch in a code to get an outside line. It makes life easier. These are just some of the things you should consider to ensure that what you need to get done gets done quickly and efficiently. And this leads us to our fourth element, dedicated war room support. Beyond your dedicated staff of partners, associates, paralegals, and legal assistants, you will also need production and presentation staff to update the presentation database in the evening and provide courtroom support during the day. As you plan for the next day in court, impeachment exhibits or redacted documents may need to be added to the presentation database. Witness notebooks may need to be updated with document pre-treats to emphasize key language for the presenting attorney as seen here. Remember, presenting the exhibits and annotating the key language on the fly will help avoid leading objections during direct examination. I'll be showing you an example of this later on in the presentation. The ability to create synchronized transcripts and edit deposition clips should be available on-site. These clips can be added to the witness outline for immediate retrieval. Clips can be presented in a variety of formats, including full screen, split screen, showing video and the exhibit the witness is talking about, or just text when you're presenting audio such as a phone tap or other audio recording. These formats are the most commonly used, but Trial Director 6 has the ability to choose among 8 different presentation formats for synchronized video and audio, and I'll demonstrate that in a few moments as well. The ability to create and edit graphics should be available on-site without the need to send the files back and forth between a third-party vendor. Timing is crucial in a war room environment, and many changes come at the last minute in the 11th hour, so the expertise needs to be there on site. Here's something else to consider. If the presenting attorney would like more control over the presentation, you can easily produce an automated witness notebook. Barcodes can be added to every exhibit page in the witness notebook, allowing the presenter to pull up whatever page in order they would like, and do it instantaneously using a barcode reader. The reader shown here is about the size of a keychain remote. Referenced exhibit numbers, impeachment clips, and graphics can be converted to barcodes for instant display right from the attorney's outline. Some lead time is required, so be aware of this before promising it to the attorney. Often in complex litigation, The workload will require that the presentation database in the war room is being updated at the same time edits and redactions are occurring on the presentation database in the courtroom. You will need to merge these two databases at the end of the day. There will be times where file conversions are necessary to reduce the file size of an image, or graphics need to be created or edited. If you have all your synced depositions in LiveNote, you'll need to convert the data to something you can use in the presentation database. If there are playback issues with deposition video clips, you may need to transcode the video to resolve the problem. These are just some of the technical support issues your assigned presentation tech will need to face on a daily basis. And this brings us to the fifth essential element, which is trial presentation support and who will be technically supporting your case in trial. Murphy's Law says that if anything can go wrong, it will, and at the worst time possible. The question is not whether something will break down during your presentation, but when, and how quickly can you recover from it. Who can you count on to help you present the evidence with speed and as little technical delay as possible? The dedicated trial presentation consultant spends an average of 14 hours per trial day, including in-court presentation and war room support. If you add this workload to a paralegal's already hectic schedule, you can easily see how this could be overwhelming and impractical, especially trials on the fast track or very complex and document-intensive litigation. Does your paralegal have the ability to outfit a courtroom with equipment and troubleshoot any issues that may arise? Your in-house IT staff may have the technical ability to run the software and troubleshoot equipment issues, but may not be able to create or edit complex graphics on the fly. Does a presenting attorney possess these skills, as well as the time needed to orally present the case effectively for their client? What happens if the system freezes during opening or closing arguments, or video edits need to be made before playing a witness's testimony in the next 10 minutes? What if a graphic needs to be redacted or edited due to a last-minute court ruling? The following clip is 1 minute 48 seconds in length. That's not very long, is it? Well, when a computer glitch occurs, it feels like hours of delay.
Your Honor, we're going to be walking through a PowerPoint presentation with Dr. Schaefer. Do we need to switch anything? Okay.
Would you like to begin?
Let me see how it shows up, Your Honor,
All right.
please. I consult with that IT person, the deputy, Your Honor.
So I was conferring with Deputy Jones.
While that's rebooting, Your Honor, I do have a hard copy of the slides that I'll be going through. I'd ask that this multi-page document entitled Propofol Not Orally Bioavailable be marked Peoples. Is it 216, Your Honor?
It is. And how many pages, please?
This was supposed to be a simple PowerPoint presentation. Don't let this happen to you. If your case is worth going to court, then you really need to consider giving it the resources it deserves. Let me give you another example. I was the hot seat presentation consultant on a high-profile pharmaceutical case in Los Angeles, and the attorney giving the closing arguments had waited until the last minute to begin preparing, which, of course, was the night before the event. I and 4 other graphics consultants worked throughout the night creating over 90 slides for the presentation. This is only 2/3 of what we are going to show. Even though it wasn't finished, I had to get to the courthouse, so I took what I had on a thumb drive and the graphics guys continued to work on the remaining slides. When I got to the courtroom, I set up as quietly as possible because the other side had already started their closing arguments. I loaded the presentation onto my laptop and began testing. I was hoping that I would receive the rest of the slides by the time opposing counsel had finished their arguments, but this wasn't to be the case. Our side began, and we went through 88 slides before one of our graphics consultants tapped me on the shoulder and handed me a CD with the remaining slides. I inserted the CD into my laptop and opened the slides in another PowerPoint slideshow and waited calmly. As the attorney moved from slide 90 to slide 91, I quickly moved from one presentation to another, and we went through the remaining slides without anyone noticing that a change in presentations had just taken place. Having the right person for the job is key to a smooth presentation, and so is a crack team of war room support staff. We'll talk about the advantages of hiring outside consultants and what to look for in a few moments. One key advantage of using trial presentation software is the immediate display of graphics, documents, and deposition testimony. The presenting attorney has instant access to their entire pool of evidence in a way that's both dynamic and flexible, something you can't get with PowerPoint. We also talked about naming conventions earlier and how using Bates numbers as a page number reference can lead to confusion and delay. You also need to avoid relying on document page numbers as an exhibit page number. Some exhibits have a cover page, a table of contents, a preamble, and then finally you get to page 1. When you ask for page 67, is it page 67 of the document or page 74 of the exhibit? Here's the trick to navigating any exhibit on the screen, and it works every time. Always use the trial exhibit page number at the bottom of the document. That's what it's for. How quickly you get what you need on the screen will greatly depend on your presentation style. Let me give you a couple of examples. I want you to imagine these two scenarios that I'm about to share with you as if you were the jury watching these events for the first time. The presenting attorney hands a copy of a document to opposing counsel, the court clerk, judge, and then to the witness. He asks the witness if he can identify Plaintiff's Exhibit 225, and after laying a foundation of the document's relevance and authenticity, the exhibit is admitted and the first page magically pops up on the screen. The attorney makes a note of the date and the address, as these items are magically zoomed in and highlighted. He then instructs the witness to skip to page 48, and we can see who agreed to the contract by the witness's signature. He then instructs the witness to go to page 16, and he focuses her attention on paragraph 27, which is then zoomed in and the key language is highlighted for emphasis. The presentation looks to be perfectly organized, and he appears to be in complete control of the presentation during direct and cross-examination. Now, let's look at another situation. The presenting attorney asks for an exhibit by its description, the July 24th contract, and approaches the witness. The paralegal and presentation tech scramble to find an exhibit that matches his description in the exhibit list. Opposing counsel stands and asks for clarification on what exhibit number were we all supposed to be looking for. He turns, frustrated by the interruption, and walks back to the podium to consult his notes. After a moment, he identifies a trial exhibit number as Plaintiff's Exhibit 225, and the clerk makes a note of it. After laying a foundation of the document's relevance and authenticity, the exhibit is admitted and the first page pops up on the screen. He then directs the witness to go to the signature page, and everyone begins searching the exhibit. He looks back at the paralegal and tech, wondering why this page hasn't appeared on the screen. It finally appears, and he discusses the individuals that agreed to the contract with the witness. He then directs the witness to go to paragraph 27, and everyone begins searching the exhibit again. It's a 200-page document, so it should be easy to find, right? After a few moments, he looks down at the page number on the exhibit and clarifies that paragraph 27 is on page 16, and the page immediately flashes on the screen and paragraph 27 is called up and highlighted. I see this happen time and time again, and it still makes me cringe. Regardless of your presentation style, using the second method of presentation will cause delay 99% of the time. To speed up the presentation, you can have these items arranged in folders in the presentation software, but you need to display them in the order to take advantage of the speed. What happens when you go out of order or ask for something that isn't prearranged in a folder? If you have to search through a list or keep track of pages in an outline, it will always end in delay. Additionally, the judge, opposing counsel, and the witness will usually need extra time finding the exhibits and pages you have described rather than identified. Many times they'll need to ask for the exhibit and page clarification anyway, just to speed up the process and keep a clear record. All of these delays can easily be avoided by verbalizing the exhibit and page numbers. It's simple and much more effective. Now I'm going to show you a few examples of some of the presentation effects in Trial Director that will help get your point across in the courtroom. Some exhibits I pre-highlighted, but you can annotate exhibits on the fly, and I'll show examples of that as well. This entire presentation was created using Trial Director 6.4, and what you see here should reflect the response time you would see at trial. Just about every exhibit that you can present digitally can be presented with Trial Director. Documents, photographs, surveillance video, graphic images such as charts and graphs, and animation. Here I'll zoom into the animation. You can move the call out anywhere on the screen. This is great for surveillance video to show drug exchanges or key footage during a store robbery. And as we're showing here, you can do it on the fly. If you have access to the internet, you can even present live websites or open other HTML files from downloaded websites. You can also present audio transcripts from telephone conversations.
911, what is your emergency?
I've been in an accident.
There are 9 presentation zones, and you can compare up to 4 exhibits at a time. Or, you can present an entire folder of exhibits in a carousel format. You can compare signatures to show the authenticity of a document. Here I'm going to show how a signature was copied from an original document and forged onto another. You can annotate exhibits on the fly or pre-treat them beforehand. I wouldn't suggest cluttering a document to this extent, but it gives you an idea of what can be done. Zoom callouts and highlighting are used most of the time at trial. This technique focuses the jury on a specific paragraph, sentence, or word. You can even enlarge tiny text. Or continue a paragraph from one page to the next. You can present deposition video with the synchronized transcript in various formats in Trial Director.
Had you ever, prior to today, that GFC had kept what GFC referred to as a phone log related to...
As you can see here, by simply toggling through the presentation layout options, I can move from one presentation format to another. It's very quick and easy.
Prior to the filing of the first amended complaint that the phone log existed?
I don't know.
Do you have any recollection of reviewing the phone log prior to the filing of the first complaint?
I don't remember.
Since Mr. Smith's deposition...
Just so you're aware, what we reviewed was like prior to filing the first amended complaint, they set up with these big accordion folders.
Excuse me, Stacy, there's no question pending.
Okay. I was going to try and tell you what we reviewed. That's fine. And let me just say, if the phone log was part of that, then it was part of what we reviewed.
If you've redacted specific words from the transcript due to a court ruling, you can present the video without closed captioning.
Would you hand the witness Exhibit 417, please?
You can also show graphics and other exhibits at the same time as well. For example, here's a document the witness is discussing.
417?
Yes.
Okay, I got it.
Sometimes you want the jury's focus on the witness or presenting attorney, so blanking the screen is an effective alternative as well. These are just a few ways exhibits can be presented quickly and effectively in court. But another important aspect of presentation support is the ability to edit graphics or redact documents on the fly. If the judge rules that certain portions of an exhibit must be redacted before they're shown to the jury, it's a good idea to have a printer in the courtroom and the technical know-how to accomplish the redactions quickly. This is more effective if done while the witness is on the stand and in the moment, rather than having to wait until the next day to produce the document. A dedicated presentation support consultant will have the ability to accomplish this as well as edit graphics and video clips at a moment's notice. They can also provide the daily support of the presentation system to ensure that the system works flawlessly and resolve any issues before they become an issue in your next presentation. Systems can fail and software can crash. It's a fact of life in the courtroom environment. Whether anyone notices is entirely up to the technician running the system, which is why this position is called the hot seat. Many of these issues can be resolved by testing the system prior to the presentation. Let me give you an example. I was providing support in a class action lawsuit in Seattle a few years ago, and discovered why going green may be good for some things, but presentation equipment wasn't one of them. I noticed in the first week that some exhibits weren't displaying in a timely manner, taking about 10 seconds to finally appear on the screen. Once it was loaded into the computer's memory, there wasn't a delay. This can be nerve-wracking to both the presenting attorney and the tech consultant. I was using a new external hard drive which contained the entire case data. There were over 1 million pages of documents, 75 deponent video depositions, and graphics. Back at the war room, I tested the system with various documents and exhibits when creating the database, and everything presented quickly. I left for a while and came back to test it again. There was about a 10-second delay, and then everything was working again. The problem, I discovered, was the hard drive. To help conserve energy, the drive would stop spinning over a certain period of time when the drive wasn't being used, which was usually during opposing counsel's examination. When I called up an exhibit, there was a delay as the hard drive spun back to life and the software was finally able to display the exhibit on the screen. There are USB settings you can change in the operating system that will turn the energy conservation feature off, but some drives are designed and built to work that way. I now use high-end notebook computers with a secondary internal hard drive to store case data and try to use custom-built external drives only as backup or when the case is too large to fit on the notebook. Even the simplest things can delay your case before a jury. In a recent article during a murder trial, a veteran prosecutor, to save money, recruited a young intern to help him play a DVD of video clips. You would think that playing video from a DVD would be more reliable than playing video from some presentation software, right? Well, as minutes turned to hours of fiddling with cables and switchers, the intern was finally able to connect the attorney's notebook computer to the courtroom's presentation system, and they were able to play the video. It sounds unbelievable, but according to the article, the effort delayed the trial for almost an entire day. Here's another example. I was in a multi-party litigation recently where one of the defendants, a large auto manufacturer who could have easily afforded a qualified hand in the presentation, opted to use the assistance of another attorney. The assistant had multiple PDF files on their computer desktop and was projecting a mirror image of that on the screen. Whenever an exhibit was called out, she would hunt through these files on her desktop, double-click it, type in the page, and then zoom in and out the best she could. It was very cumbersome. By using Trial Director, our presentations were so much faster and organized. It became apparent that the jury was losing focus as they breathed a sigh of frustration each time the attorney called for an exhibit. After 2 days of embarrassment, the attorneys hired a trial consultant themselves. These are just a few examples of the hundreds I've experienced since I began consulting in 1996. Many of the resolutions to technical issues come from experience and being on the front line, where creativity and ingenuity matter the most. So, the question remains, who can you count on to help you present the evidence with speed and as little technical delay as possible? There are many advantages to hiring an outside consultant beyond the subcontractor benefits from a financial and tax-related point of view. Like an expert witness, you are paying for expertise and experience. You want to be able to sleep at night knowing that what you need for the following day will be there when you need it, and technical issues, if any, will be taken care of quickly and professionally. Here are just a few things you need to consider when hiring a presentation consultant. There are trial consultants and trial technicians. What's the difference? A trial technician knows the software and can troubleshoot most equipment and database issues. A trial consultant usually has more experience in the courtroom. Not only do they provide all of the technical skills, but they can also develop or edit graphics, video, and provide feedback on what may be going on from a juror's point of view. This feedback may be based on other similar trials they've attended or just a fresh look from an outsider's perspective. After all, we're new to your case and can offer a fresh perspective. For really small cases, a paralegal or technician may be all you need, but on larger cases, a consultant will give you the best bang for your buck. When selecting the right consultant for your team, perform your due diligence and ask about their experience, how long they've been a consultant, and how many cases have they supported at trial. Check their references. Were the clients satisfied with their work? Were there any problems they encountered with the work performed? Were the problems resolved? Would they use a consultant again? If you are working with a consulting firm and you've gotten to know the trial consultant you would like to hire for the work, ensure that the consultant you want is the consultant you will end up with at trial. Sometimes consulting firms will lowball their fees just to get the work. During the sales presentation, they may have their most senior presentation consultant give a demonstration on the skills they will provide the client at trial, and when the day comes to present their case, a greenhorn technician with 1 or 2 trials under their belt will be assigned to your case. Don't let this happen to you. Some consulting firms will provide you with presentation software for free if you use their firm. It may sound great, but the software that's usually provided is proprietary to their firm and cannot be purchased off the shelf or over the internet. If things go badly and you want to hire another firm, you'll have to purchase another presentation software, and any databases that were created may not import smoothly into the new software. It's generally best to go with a brand name software package like Trial Director or Sanction. Good consultants are typically busy consultants, so it's important to choose and retain your consultant early, weeks if not months in advance of the trial date. Unfortunately, we are usually hired just days in advance of trial, which is usually due to the breakdown of settlement negotiations, and everyone is in a rush to prepare for trial. As consultants, when we're hired on short notice, it gives us less time to know your case and document database. We cannot as readily anticipate which exhibits you will want to use at any given time. However, as discussed before, calling out the trial exhibit number rather than a description will close the gap and will provide you with a smoother presentation experience. It's also important that you check for party conflicts. Has the consultant worked for opposing counsel on similar cases, or with the same client? Is there a conflict of interest? Make sure that you've thoroughly checked with the consultant to ensure no issues will delay your case moving forward. Whatever your budget may allow, make sure you outline the specific needs you are expecting your consultant to perform, and ensure all interested parties are aware of these expectations back in the war room. For example, you may have hired a graphics firm to create the trial graphics, and you need to limit the presentation consultant to handle the database and trial presentation work only. Or you may need the trial technology consultant to do it all. Get a cost estimate with varying budgeting options depending on the work performed, including role limitations. If you have a really tight budget and you want to cut down on hourly rates, here's a suggestion that might help. Have another paralegal or one of your IT staff develop a presentation database and update it each day, and have the consultant provide the courtroom support only. This will limit the hours billed by the consultant closer to an 8-hour day. Once you have the estimate, look it over. It's important at this stage that you don't base your decision on price alone. This would be a mistake. You can hire a teenager from a local high school to run your presentation just because he's the cheapest and you've heard he's good with computers. This too would be a mistake. You can always find something cheaper if you look hard enough for it, given enough time. But generally in this business, you do get what you pay for. The estimate should include the consultant's hourly rate, estimated number of hours to be worked, and any equipment rental costs for the length of the trial. Pay close attention to the estimated daily rate. Are the numbers reasonable? Unless you're scheduled for half days in court with no other work assigned for the consultant, chances are slim that 8 hours a day will be close to accurate, especially if war room support is involved. Some firms try to lower this number to make their proposals look less expensive than their competitors. Another thing to look at is the equipment list. Can you cut costs by supplementing the equipment list with equipment you already own, or splitting the costs with opposing counsel? We all know that cases settle, and more often than not. And even though a lawyer has been in practice for more than 30 years, they may have actually tried less than a dozen cases in that time. Presentation consultants, on the other hand, are in trial on a daily basis, month after month, year after year. Now, it is true that most of the consultants you hire may not be attorneys, but they've seen their fair share of presentations. They've seen dozens, if not hundreds, of opening and closing arguments. They've seen expert witness testimony win cases or lose cases. They've presented at hearings, arbitrations, focus groups, and bench and jury trials. As I've said before, many times they come into the case at the last minute, like jurors, and they haven't had a chance to form an opinion about the case. Don't be afraid to ask their opinion on how they think the trial is going, and let their experience work for you. It's one of the reasons why I get repeat business. It's like having your own shadow juror without the extra fees. I was hired as a presentation consultant on a high-profile case in Las Vegas several years ago. The lead attorney kept asking me questions at the end of the day, and upon listening to my answers, he wanted me to act as their shadow juror as well. Each day at trial, I would write down points I thought opposing counsel had made, and I would submit a short report of how I thought the day went according to the witnesses that testified. Some points he would ignore, but many he would follow up on. During the trial, from time to time, both sides would read from Jury Instruction 24, which told the jury what they were to consider in the case and what not to consider. It was a complicated multi-state lawsuit involving tax evasion and the government's invasion of privacy, among other things. At the end of the trial, during closing arguments, the opposing counsel read Instruction 24 to the jury, but it sounded different to me. It basically suggested that everything we had been arguing for the last several weeks wasn't to be considered in the jury deliberations. I looked up at the jury and they too noticed something wasn't right as they cast glances back and forth. I looked around at our attorneys and they were just sitting back listening or writing on their notepads and didn't notice anything amiss. After a full day, opposing counsel finished their closing arguments and we broke for the evening. I handed my report to our lead attorney and suggested they check out Jury Instruction 24 against today's transcript, just to see if anything had been changed. He said he would, but there probably wasn't anything to worry about since they had gone over jury instructions the day before. Now, the next morning, the attorneys met in the courtroom outside the presence of the jury and explained to the judge that the wrong instruction had been given to the jury and demanded sanctions be brought against opposing counsel for trying to deliberately mislead the jury. Opposing counsel argued that the instruction had already been agreed upon 2 days earlier in court and the instruction should stand. The attorney for our side, that had argued the jury instructions, stated that opposing counsel had given him a hard copy of Instruction 24, so without reading it, he asked them if it was the same instruction which had been read throughout the trial, and they said yes, it was. Opposing counsel then began to backpedal, saying that somehow the instruction had been mixed up with a previous draft that had been developed prior to trial. In the end, the judge decided that since opposing counsel had given a copy of the instruction to our counsel, sanctions weren't warranted, but did rule that the original instruction be given and read to the jury, and the jury was to disregard all comments in opposing counsel's closing arguments regarding it. It was obvious to everyone that if I hadn't caught the error, we probably would have lost the case, and all of them thanked me. After several days of deliberations, we won the case, and the jury awarded our client a verdict of over $388 million, a Nevada state record. The last of the 6 elements are the post-trial essentials. At the end of each trial, you should debrief your presentation consultant to discuss what worked and what didn't, so that you can fine-tune your presentations and consultant relationship. Once you've found a good consultant, you'll want to work with them again and again. Continually fine-tune the system, and you will be glad that you did. You will then need to coordinate the teardown, packing, and shipping of the courtroom and war room equipment back to your office or the various vendors and suppliers. It's also important to make a backup of your entire presentation database, just in case you need to refer back to anything on appeal or if you have to retry the case. Jury persuasion is an art. There are many complexities that come into play, such as life experience, knowledge or lack of knowledge, how well they can relate to the subject matter. Ultimately, the value of the presentation will only be determined by how it fits the content being presented and the interests, backgrounds, and abilities of the individual jurors involved. By taking into account these 6 essential elements, you will see a savings in time and money. Your presentations will run more smoothly and with less interruption, and you will be more effective in the courtroom. Now I want to dispel some common myths about using technology in court. The first one I hear, especially from large corporate clients, is that they don't want to appear too slick or fancy. Trials and focus groups that have been conducted over the years have shown that jurors expect everyone to present the best case that they can, regardless of the depth of one's pockets. If you can make your argument easier to understand and remember by using technology, then that's what they are interested in. Jurors expect you to be on the cutting edge. To dispel this myth once and for all, a friend of mine, a trial consultant from Arkansas, surveyed a jury about these very issues after a fairly lengthy trial. Keep in mind, this is a small rural town in Arkansas. To keep their identities confidential, you'll see that he's degraded the video image, but what they have to say is all that really matters.
Did you feel like the use of the technology was something that was too slick? Or did it help you?
Expect it.
Help.
It helped.
You expect it now. I mean, without it, today is technology, you know, that's what it's all about. You expect to see it.
So you didn't feel like, go ahead, I
We
interrupted.
deal with PowerPoint nowadays in classroom, at my job at Whirlpool, so this is nothing. It's a new version, you know.
Right.
It's nothing we're not used to.
And it doesn't make it appear as if somebody's bringing in all the high dollar fancy equipment to make their case better, but it did assist you in being able to all see it collectively, zooming in.
I thought it was good because you could hear her talking, and that if you kind of missed a word or misunderstood her, you could pick that word up right.
That was my next question. I want to ask you about the video depositions. When you run a video and you have the text underneath, did you find it to be distracting?
No.
Very useful.
It was good, okay? Especially with the text on the bottom.
You did find it to be helpful.
I found myself going along with the words more than I was looking at the
Did you feel like, well, let me ask you this, did you feel like you retained more?
Oh, yeah.
Because you saw it, you heard it, you could read it?
Right. Yeah.
And they would hold a picture up, but you were locked in on that text. Would you still look up to see what it was they were looking at?
Yes.
And you could still go with the facial expressions of the doctors and whatnot?
Yeah.
What about price? It's too expensive, or my case is too small to worry about it. With the advent of new technology such as the Apple iPad and applications like TrialPad or Indata's T-Mobile, presenting a handful of documents, graphics, and video is easily within the realm of small cases. TrialPad is about $89, and TD Mobile is free. TD Mobile requires Trial Director to set up your case data, and it's pretty limited as to what you can do with it. TrialPad is a much better application. You will need some help setting up the database properly, and you'll want to use a wireless connection to avoid accidentally unplugging yourself from the presentation. With practice using these apps, you can easily run the presentations yourself. Just make sure you test everything prior to running the apps in court to ensure everything works as it should. If it's a large case and you are defending a losing battle, or you just don't want to spend the money, consider this. The use of focus groups, jury selection consulting, shadow jurors, and proper presentation methods can go a long way in settlement negotiations or getting the jury to award a lower verdict. Some attorneys think that just because they're attending a bench trial or a hearing, they don't need to present anything but the facts of the case by using just the evidence with the witness and maybe the document camera or Elmo. Just about every case can be made simpler, more understandable, and more interesting with a graphic or two, even if you are just presenting documents. The one thing that judges have commented on is the speed at which exhibits can be presented digitally versus sifting through boxes of exhibits and presenting them on the document camera. Using a notebook, presentation software, and projector can easily focus the attention where you want it to be. One of the downfalls of using just paper is that the witness or judge may not be able to read the small print in an exhibit or quickly follow your direction on which paragraph or sentence you're talking about. Wouldn't you like the ability to magnify portions of an exhibit at will? What if the judge doesn't allow the jury to have a binder of the exhibits during trial and all the jury is left with is oral presentation? Well, according to what we discussed earlier, you're going to lose the attention of more than 65% of your audience. What if opposing counsel uses technology and is able to present their evidence more effectively than you? You heard the answers from the jurors just a few moments ago. Jurors expect technology, and they expect you to present the best case that you can for your client. We've talked about the document camera already. What we found is that the document camera, or ELMO, should only be used in special occasions where the physical evidence is small, hard to see, or easily lost when handled by the jury, or as a backup if a document hasn't been scanned into the presentation system, or on the few occasions that you want to treat an exhibit differently, as discussed before. Otherwise, juries on the whole hate the ELMO. It can create motion sickness as zooming, cropping, page orientation, and overall fumbling of the document ends up being more of a distraction than a means of communicating effectively. If you're thinking that your secretary or paralegal can do it all in PowerPoint, think again. As we discussed earlier, PowerPoint has its limitations when it comes to courtroom presentation because it's designed for something that is linear, canned, or rehearsed, not something that you can rely on for cross-examination or arguing subjects on the fly. And your paralegal may not have the time or graphic skill to create a compelling PowerPoint presentation. These people have full-time jobs already. In the throes of litigation, the role of a trial consultant is also a full-time job. Assigning a paralegal to a case that is still doing paralegal duties rarely ever works. They burn out from lack of sleep and stress, or unintentionally drop the ball on critical steps of the process. Assigning another paralegal to be a trial consultant rarely works either, because of the graphics, video editing, software, and hardware troubleshooting that's involved. I've had attorneys tell me that they just don't have time to deal with it, which of course is one of the reasons why they end up hiring me. If you are overwhelmed, that is the best time to get others involved. Now, a little bit about my company, CourtLogger. CourtLogger provides a variety of litigation support services that are designed to help lawyers present their cases more effectively in court. Period. That's our goal, and that's what we do 24/7. We can work with you remotely from our secure St. Johns County home office or on-site anywhere in the world your trial is located. We have access to a network of over a dozen of the country's best consultants and have local support staff available 24/7. We don't have an expensive office downtown, so that we can provide our clients with ultra-competitive rates. Here, I've summarized a list of provided services based on category. When you hire a CourtLogger trial consultant, you'll be getting all of these services for the same low price. But let's say you have your own litigation support department and you just need help with a few of these services on an a la carte basis. Or you have overflow work where some trials have merged into the same time frame. We can help. On the left, you'll see presentation consulting. It comprises presentation database management, demonstrative design and illustration, animation, and interactive graphics using Flash, PowerPoint, and Acrobat. We can develop presentation boards, digital photography, and forensic imaging for video and still imagery. We provide video production and editing of any existing video footage you may have, and that also includes video clip creation, transcript syncing, transcoding video and audio formats, editing out objections and extraneous sounds or noises to improve playback in court. We of course provide presentation hot seat support and courtroom and war room technology support so that your presentations run as smoothly as possible. We also provide our own secure online client review site where you can share files easily at any time from anywhere, and all transmissions are protected with up to 256-bit SSL encryption. On the right, you'll see jury consulting. It comprises of in-court observation, like having your own shadow jury. And as mentioned before, we can also track court time and admitted exhibits, as well as providing a detailed daily report at the end of each day. We can even provide a CourtLogger Pro laptop for your paralegal to use at trial. You'll also see software development. This is used for special projects. We're all about making things easier. And so if we see a need where a certain process is taking a long time to complete due to limitations in current software programs, we will write our own software to make it easier on ourselves. And this saves our clients money as well. That concludes our presentation for today. Like I said in the beginning, if you have any questions or comments, you can contact us through our website at www.courtlogger.com/contact us. Or you can reach us by calling the toll-free number you see below on your screen, and we'll be happy to help. Until then, good luck on your next case, and we'll see you in court.